Okay, so welcome to our webinar. The way we're going to run it, very chatty, very informal. I'm going to do a little bit of scene setting. Thank you to everyone who contributed to the questions in the registration form. They've kind of accidentally captured. I wasn't expecting this, but it's really captured some rich data. So I'm just going to spend 5 minutes going through that. Then I'm going to hand over to Demi, and Demi's going to talk through her experience as an advocacy provider. Then over to Gail for her reflections from like a national perspective. And then Rebecca, who is from our friends at Erwin Mitchell. Rebecca's going to kind of bring in some of the more legal side and from Court of Protection. We've had 43 questions in advance, so thank you. We won't have time to go through them all. But we've grouped them. So we're gonna try and nail the themes and kind of pick one that captures them. If you've got questions, stick them in the chat because they even if we can't answer them today, they help inform kind of what we do next. And certainly Gail, NDTI, that national brief that helps us to think what we're doing. I invite you all to be open-hearted with today. There's no such thing as a stupid question or comment. Be honest and get those fingers in the chat box, guys. Right, I am going to share my screen to talk you through the feedback. So this is interesting. The first question we asked was, in a word, how do you feel about the Supreme Court ruling, the AGNI? And overwhelmingly, the words were what I describe as catching a negative sentiment. Most people are feeling confused, concerned, and worried, and there's a lot of uncertainty. Anger kind of featured a little bit, but it was more like a sense of disappointment and shock that came through in this feedback. That is significant, I think, because of our emotional states. So if you think about when we've got something new, which this is, and change is thrust upon us, one of the worst states we can be in is confused and worried. Because when we feel confused and worried, we kind of get a bit impotent. We become a bit stuck. And I want to invite us as a community to not sit in that place. We have to find a way, I think, friends, of feeling confident, because you're the defenders of human rights. And if you're stuck, if you're feeling confused and uncertain, then that means that we're not defending people's rights. It means our brainwidth is like in this panic mode. So I really want to acknowledge that that's how we're feeling. But let's move from that space to a more empowering position. And I've said this a few times, so forgive me if you heard me say this before. But when things are uncertain, it invites leaders to come forward. It invites people to take the rein. The leaders in this group will be setting the tone for the next 10 years. The guidance hasn't been written. There's an opportunity here. There's a window. You've got stuff to say about people's rights. You've got ideas and thoughts about what these safeguarding should be. Now is the time. Let's not be passive. Let's be assertive and advocate. So that's kind of the starting point. I've only got 3 slides, don't worry. The next question we asked was, how would you describe your experience post-AGNI? So, I'll time stamp this recording. So today's the 28th of July. So we're just coming up to 2 months after the Supreme Court judgment. Overwhelmingly, people are saying that they're uncertain. The overwhelming feeling is people are not sure about what it's going to look like. But what was interesting, I thought, was the next top feeling and acknowledgement, which was actually a fifth of the people who replied to this little question have said, actually, we've not seen any change. And I think I'm a bit surprised at that because the ruling is the law now. It's not like it's going to be implemented. That is the law today. So if there's been no change, that's a bit. I don't know what the other panelists think, but just chip in. But that makes me a little bit worried, a little bit. Oh, is that uncertainty across the whole health and social care sector making us feel a little impotent?
I wonder if it's that for the people who haven't experienced change, whether it's because their local authorities haven't quite got to grips with what AGNI means and the impact on them, and so it's not changed yet. I mean, hopefully it won't change; it'll stay as it was. But it might mean that it won't. It will change in the future once they've had more challenges. Once they understand what the consequences of the decision is, there might be change to come later. So.
And I think that the interim information that we've got from Department of Health and Social Care kind of urges, I think, not to rush to change. It makes it clear that if people are still on a deprivation of liberty safeguard, that in the interim while we're working things out, it doesn't mean that's an unlawful deprivation. It urges that advocacy continues, that RPR continues. And so maybe that's one of the reasons why, is that there's that kind of explicit level of caution out there in the information that we've had so far.
Yeah, yeah. Thanks, guys. People also feeling that emotional overload. They're feeling anxious. People are using the word distressed. Lots of advocates and colleagues are worried about the safeguards being lost and just removed overnight, and that's causing anxiety. And then, yeah, a few people are having positive, constructive experiences, and then inconsistency. So even within regions, different care homes responding differently. I've just seen a comment in the chat box. Somebody's experience of judges kind of varying in their interpretation. So it's all we are really in early days, aren't we? But it's important to capture this. I think this is helpful. I know I really enjoyed reading people's comments. And just so people know, I am going to write something a bit more formal based on the feedback because there was such rich data in what you guys have shared. So there will be something coming. We also asked, have things changed in practice? And look at that. Of course, people said no. So it's very similar, what's your experience in terms of how do you feel, and then what's the practice? I just think this is very, very interesting, and it's almost like I think this has given us some real strong intelligence to go to DHSC and say these are the things that people are crying out for. This is the guidance that we need. So I'm going to stop sharing. I hope that's wet your whistle. Engage in this next hour through the chat function. Share your ideas, share your comments. We're a group full of advocates. We're not meant to be quiet. We're not meant to agree either. If there's anything any of us say that you disagree with, for God's sake, don't keep it to yourself. We are figuring this out as well. And I think all four of us have come today very much in the spirit of open-hearted. This is what we think. We don't know. We don't know. Demi, can I pass the baton to you to pick up on your thoughts?
You can. Thank you, Kate. So just for context, Gail and I do co-chair a DOLS and RPR subgroup of the Advocacy Network, which is attended by advocacy providers of different sizes. We've got some national providers and some smaller providers, and basically from all over the country. We've met a couple of times since the judgment, so we've been able to have some really interesting discussions about what we saw initially a week after the judgment was handed down, and then how we've seen things develop over the week. So it's been really interesting to see how people have had different experiences based on the local authority area that they're working with. And I think the slides that you shared, Kate, have shown that at the moment it is all a little bit of a mixed bag, and that's been the responses that we've and the discussions that we've had in that group as well. Providers experiencing very different things depending on the local authority area that they're working with, and I think that relates back to the points that Rebecca and Gail were making in terms of it will very much depend on how local authorities are getting to grips with things, but also the guidance as well has sort of urged that we sort of err on the side of caution in terms of current authorisations, at least anyway. So some providers haven't really seen much difference in how things are working at the moment, and I think that's very well reflected in what you've shared, Kate. Some people have seen a very sharp drop in RPR referrals coming through. For some cases, that has been because the local authority have had to go back and review all of the authorisations that might have been ready to be signed off before the 2nd of June. And then they were all sort of sat waiting to come into force, but post 2nd of June, all had to then be reviewed. And for some of the bigger local authority areas that providers are working with, that could be quite a big number of pending authorisations that then need to be revisited by those BIAs, so slowing down assessment processes potentially. And then following the DHSE guidance that was released, some local authorities are focusing on assessing people who are objecting to their placement, as at the moment it seems slightly clearer to determine whether someone is deprived of their liberty if they are objecting. So whilst providers are reporting that they might be getting fewer referrals at the minute, some advocacy providers are getting a higher proportion of referrals of people that are unhappy. And then also following the DHSE guidance, some local authorities aren't setting out to review those existing authorisations where that would be like a really big undertaking. But when the opportunity does arise naturally, so if somebody does submit a review request for a different reason, such as additional restrictions are coming into place, BIAs may then consider whether the person remains deprived of their liberty whilst they're doing that part of the review. But otherwise, those authorisations may just be left to lapse until they expire, at which point they may reconsider whether someone's deprived then. So again, that may be another reason why some people aren't seeing much change, in the sense of they're still working business as usual on those referrals that they've already got. And if those referrals were received like sort of May, that's going to keep them busy for the next year in that sense. Advocacy providers have also reported that they've seen quite different attitudes from different local authorities towards the judgment. So some have been really proactive, have listed the judgment as a topic for discussion on their safeguarding adults boards. Professionals and commissioners have been really keen to understand how this impacts people that potentially won't have an RPR moving forward. And some have reached out directly to their advocacy providers to talk about other advocacy models that could maybe be implemented, put in place to address that gap in advocacy support. And that sounded really, really positive. But then unfortunately, some providers have reported that their experience has been the exact opposite of that. Some commissioners have not really been happy to engage with those discussions. It's not really been treated as a priority in terms of those safeguarding and adult boards discussions. So yeah, a real mixed bag from what's been shared. You touched on before, Kate, that there's been a big variation in terms of the approach of care homes. And again, that was something that we discussed in subgroup, something that I've seen personally as well, that just a massive variation in their approach, and not just from necessarily area to area, but even within the area that we're working as well. Some care homes are very aware, but it seems that the majority of them aren't. Of the care homes that are aware, we have heard of some care homes sort of then going on to say that means that they won't be submitting any more DOLS applications. And thankfully, some DOLS teams have then got involved and had further conversations with them about the judgment and what it means and what their responsibilities are. But then at the other end of the scale, we've also seen some really great practice from other care homes as well. And one example was shared with us of a care home who worked closely with an advocate to challenge a decision from the DOLS team that the person wasn't deprived of their liberty. The care home felt that due to the restrictions in place that they were deprived, and so they worked with the advocate closely on that, which is a great example of practice, and again, really positive to see. So some of the guidance that has come out since the judgment and since we last all did this webinar, and the conversations that have happened since then have been quite helpful. But as advocates, there are still lots of things that we're worried about, I think, as the responses that you shared earlier, Kate, show. And a lot of things that we're worried about are about safeguards for people. And I think that's reflected in a lot of questions came in about how people will be safeguarded without having the DOLS authorisation in place, without having an RPR. And a lot was made in the judgment about other legislation. And of course, people do still have the safeguards of the Mental Capacity Act, the Care Act, the Human Rights Act. Of course, they're still there. But I think what advocates are most worried about is without advocacy, how effective those safeguards will be. Because ultimately, that legislation is what we're relying on as advocates when we're challenging decisions. How often do we see decisions have been made, restrictions put in place for people without the relevant legislation being followed properly? And that is what our challenge is very often based on. There's no documentation that this has been done in someone's best interest. There's no documentation that there's been consideration of other less restrictive options. And I think something that we touched on last time is that still application and awareness of the MCA within settings is still very, very variable. So how much of a safeguard is that legislation for people if it's just there, but it's not followed or always applied correctly, and there isn't an advocate to flag that up? So fewer people are ultimately going to have access to an RPR, and so there's going to be less advocacy involved. And Kate, you've given a really passionate call to arms for advocates to find a way to stay involved and ensure people have advocacy support, whether that be through Care Act advocacy or residential visiting advocacy. And I'm sure advocacy providers will be looking into that, looking at ways to push Care Act referrals for the people that they're aware of that will lose access to an RPR. But I think maybe what we're still worried about is the people that we don't know about. If the care homes aren't submitting Form 1s to the DOLS team, if they're not on the local authority's radar and we're not in there, we've not got a presence, we're not visiting as frequently, how do we get to know about them? How do we get to push for those referrals? And there'll be people that we are aware of, but they aren't eligible for Care Act advocacy. Maybe they're not local authority funded. Maybe there's reasons there where we can't necessarily push that referral. And residential visiting, that model of advocacy is beautiful and really powerful, but isn't a statutory role. And whilst I'm sure providers will be looking at meeting with commissioners as much as they're able to, discussing what they can offer and being really, really persuasive, passionate, demonstrate why that support is needed, we need that bit of guidance to actually say this advocacy is needed, because that is what then puts the onus on commissioners. So like you say, we do have an opportunity in that ambiguity and in that uncertainty to put forward, these are the main concerns that we have as providers, and this is the gap that we feel we're going to be left with, and how can we try and plug that and address that? And I think there's one safeguard as well that there's been a lot of conversation about in terms of being lost is, and it isn't protected by other legislation, is that if a person doesn't have a DOLS authorisation, is that lack of then non-means tested legal aid. Judicial review isn't as straightforward as a Section 21A challenge, but also they don't do the same thing. So there's a worry then about people where maybe Section 21As have been started on the basis, not necessarily that the person is very evidently objecting, but because the placement doesn't appear to be in the person's best interests. Someone who maybe wasn't objecting because maybe they've become compliant, or they've not been able to express their views without support, or they've not been aware that there were alternatives that could even be explored. And advocates spend a lot of time getting to know people, understanding their communication, and can also observe when people's needs don't appear to be met in those settings. But in these situations, the person might not even be eligible for a DOLS authorisation. And that is a situation where a Care Act advocate absolutely could make a difference. But once they've exhausted all options, asking the court to intervene isn't as straightforward as it is when we've got that DOLS in place. But also assuming that a referral is made, or that the advocate becomes aware of people in these situations, again, bringing us back to that worry that advocates are going to be worried about the people that we don't know about. That's maybe going to be the biggest worry, because without an advocate building that relationship, asking questions, would a Care Act review necessarily be triggered in that sense? So as we've discussed within the subgroup, and as we've seen today through those responses, the picture across the country is still emerging pretty much. Some local authorities are responding really thoughtfully and proactively, working with providers and considering how advocacy support can continue to be available for people who don't have an RPR. Others are maybe still trying to work through the practical implications, and inevitably that's leading to a great deal of variation. And yeah, as a sector, like I've said, I'm sure advocates will be very creative, persistent, resourceful in finding ways to try and support people. But I think there does remain that risk that some people will fall outside of statutory advocacy and become harder to identify and support, especially if non-stat models aren't funded or there isn't that guidance to push for that.
Thanks, Demi. That was brilliant. Thank you. And I'm being keeping an eye on the chat box. There's lots of people sharing beautiful examples of concern and approaches and gaps which you've drawn out there. So thanks for that lead. Thanks, Demi. Gail, I hand over to you.
Thanks, Kate, and thanks, Demi. So I guess sort of following on from what Demi was talking about, we've got that wonderful little group of advocates and advocacy organisations who are coming together to talk about what's happening kind of live. We're keeping on those conversations and we're starting to feed those in now to colleagues at Department of Health and Social Care so that we can share our learning, share the picture that we're seeing, and hopefully so that that can start to influence the next layer of interim guidance that we're expecting and anticipating. So it's really, really important that we have as many voices from the sector involved in those discussions as we can to make sure that we're able to kind of advocate for advocacy and advocate for people who draw on advocacy as much as we possibly can. I was thinking about the guidance that we've got and that kind of interim information that we've got from Department of Health and Social Care. Actually, I think is really quite helpful. So whilst it's confusing, we don't know really how we should be applying those factors in the multifactorial test or which has more weight. That interim information is urging a proportionate, I think the words are proportionate and considered approach and really careful decision making. And if there is any level of doubt about whether or not somebody's deprived of their liberty or if somebody is objecting or not, that information, that guidance urges that we continue to use DOLS processes and court applications as we have been. It also kind of reiterates that point that I think lots of people have been really worried about. It's saying really clearly in there that where a DOLS authorization is in place, that people aren't, and that's not yet been reviewed, that people aren't unlawfully deprived of their liberty. So even whilst the legislation has come in now, that's the legislation that we're working to, that information kind of does make clear people aren't it says, you know, people shouldn't be being considered as being unlawfully deprived. That guidance also talks about the fact that it's local authorities and managing authorities' responsibility to start sharing that information and upskilling the workforce. And I've seen in the chat that there's really different experiences there and RPRs sort of taking it upon themselves to share that information. That I would really point people back to the information that's publicly available as well about, you know, what their roles and responsibilities are. That information talks about the fact that we're expecting an NHS England e-learning module by the end of this month. I couldn't find anything so far, but maybe that's on its way. And I think the other thing that was really stood out to me in that DHSC guidance or information, it doesn't call itself guidance, does it? But the information that we've had so far re-emphasizes that access to advocacy and RPR should remain, I think the words are where applicable. And I think that's also really, you know, it's information that we can use. It's publicly available information that says advocacy should remain available to people where applicable. Now, where applicable's up for debate, isn't it? But where we can describe what's applicable, why it's really important that we continue to provide that advocacy support to people, then we've got that it's there in writing. And people's access to advocacy is wider than RPR and it's wider than your IMC 39A, isn't it? Yes, we've got Care Act advocacy. And Kate, you and I have talked loads over the years, haven't we, about what happens when we silo advocacy off into our kind of really narrow roles and remits. And actually, advocacy has always been about supporting people's rights, supporting people's voice, supporting people's choice. And if we've got an opportunity here to widen up how we're thinking and talking about advocacy, then I think that's one we should hang on to and talk about. So wider than DOLS, wider than RPR, people have rights to advocacy, and we need to be carrying on talking about that. That ADAS have also shared a little kind of toolkit, I think, about how I think they're calling it a priority checklist or something like that. I'll share the link in the chat in a minute, about helping supervisory bodies, and I'm guessing managing care homes and as well, about what is likely a deprivation of liberty and what's likely not a deprivation of liberty, and reminding folk of their responsibility to refer to IMCA. And wouldn't it be great if that talked more broadly about advocacy, but it does talk about IMCA. So yeah, we've got some chances, I think, as Kate said, to influence the interim guidance that's being developed. I think it's really important that we've got a kind of broad sector voice within that. And so really encourage folk to get involved and share their thoughts and share their experiences. Yeah, thanks.
Thanks, Gail. We will put links to the guidance. I mean, can we just have a quick flurry of yay or nay in the chat box? If you've seen the DHSC guidance, and there's no implied criticism here, just yay or nay. Oh yeah, is that a Scouse thing? Yeah. Okay, so a few no's, but most people are using it. So we'll share. There's a few things. There's the ADAS, there's a priority tool that Gail mentioned, and the other amazing source is the Open Justice project. Is that right? But their work, their website is beautiful. So we'll put links to. Well, they're in the slide deck. So we'll send. Thanks, Gail. Rebecca, over to you for the light-hearted part of the talk.
Thank you. So just a little bit of context. So I work at Owen Mitchell. I'm a solicitor here, and me and a couple of other people represented the charities in the case, in the AGNI case. And I mean, what I can say is that all these concerns and all these issues that you were raising in this talk we considered them very carefully, and we made it very clear to the court that there was going to be confusion if you remove the acid test. There's going to be inconsistency in how it's going to be applied, and our major point was the fact that we were very concerned about the lack of advocacy. If they went forward and they changed it, we were going to be very concerned that people were going to be left without a voice, and there was no right for somebody to go into there. So I mean, it's of cold comfort. But I can tell you that we did stress the need for advocacy within that, and the Supreme Court has made that decision, and they think that's lawful. We did our very best, and we had a very clear argument on it. But we're left with AGNI, and I think what I've been hearing today is what we anticipated would happen, and I mean, there's always been inconsistency, depending on what local authority you get, depends on what sort of reaction you get. And, we know that certain ones are going to respond differently to other ones. That sort of comes with experience. But I think, we're trying to look forward and how we manage the new world with AGNI. Yes, it's not as easy to get a Section 21A application into court. Well, no, it's easy to get a Section 21A application to court if you've got standard authorisation in place. It's to say that's not changed. There's a standard authorisation. We can take it to court. We can challenge it. The question is when there's not a standard authorisation in place. There are still court protection proceedings. So you're not looking at, if it's not a Section 21A, we've got to go to judicial review. Straight to that. There are Section 16 proceedings which can be brought, and those can be brought because of it's a question about best interests, question about contact, question about use of internet, question about marriage, sex. All those things are still covered within the normal remit of Section 16 cases, and so there are still and legal aid is still available for Section 16 cases. The question is this non-means tested legal aid. So if you do manage to get in there, you do manage to see people, and there are clear issues. We can go to court on those issues. We will need evidence of bank statements, so 3 months bank statements, so we can see if they're eligible for legal aid. And if they are eligible for legal aid, we can apply for legal aid. If they're not eligible for legal aid and there is a case, then we can look at, you know, is there something we can get a court order for, so we can bring, so we can investigate their finances and get authorization that way. So it's not, you know, just because there isn't that sort of streamlined process into court through Section 21A, it doesn't mean that the court protection is off limits. It is still there, and it's still there to make those best interest decisions on behalf of people. There is, of course, judicial review as well, and again, there is legal aid available for that. But Demi's quite right in that what judicial review can do and what court protection can do are two different things. But there is that lever to pull as well. There is legal aid there as well. So, so in terms of, you know, I think one of the key things to look at when there are places in restrictions in place is that are they the least restrictive possible? You know, that is within the legislation, that's in the Mental Capacity Act, and that is one of the things to look at. In terms of the proceedings, what we've noticed is there is a variance across the local authorities and how they're reacting to it, but you know, we've still got quite a lot of Section 21 cases. We've got quite a lot of Section 16 cases at Owen Mitchell as well, and we're progressing with those. And I think and I think it's quite often been a lever to get it into court as a deprivation of liberty. But when you're in court, what you are looking at mainly are these best interest decisions. You know, are they living in the right place? Are they receiving the right care? There's often issues about who they see. Can mum, dad, wife, child come and visit? You know, can they go out to the community? We have nearly all my cases we deal with is access to the community. Can they go out to the community? We've always got to ask these questions. And, you know, why are they not going to the church they want to go to? And these are the things that we're dealing with. So it's the nitty gritty of people's lives that we, you know, once it's into court, that's what we're looking at. And that's still what's happening now. When it comes to the specific question of how the deprivation of liberty is dealt with, then throughout the context of the proceedings, you know, if it's unclear, we ask them to provide more evidence on that. We ask them to provide their sort of submissions on whether or not it amounts to a deprivation of liberty or not, and then the court can then consider whether it's not it's a deprivation of liberty. So we were asking for evidence, and then we're going to ask for the courts and the judges to make a determination on it. So they'll hear an argument, and then they'll make a determination on it. Now, I'm aware that their Open Justice have been sitting on some of these hearings which have been taking place. Kate sent me 3 cases before I came on to have a look at, and I think the difficulty with Open Justice is that they're doing a great job reporting, but the problem is you're getting a piecemeal response from the courts as to what's been going on, and you've not actually got the full judgment as to why they made the decision, how they made the decision. I'm aware that Judge Burrows in the Northwest, he's told one of my colleagues that he's got 2 judgments he's going to write up about whether or not they amount to a deprivation of liberty. But as far as I'm aware, they've not come down. He's not finished writing them yet. So there are cases going through the court, and there will be judgments handed down on it, but we haven't actually got any judgments yet. So so we're still in a sort of wait and see aspect of it. But I think that, and different judges will deal with it in different ways, of course. So the test is so wide, there's so much room for interpretation in there, we're going to get different responses, and I think it's going to take a while before it's settled down. But I think in terms of, there's been quite a sensible approach taken with the courts so far, setting it down for evidence, and there's been quite and we're just waiting further judgments on it. In terms of, you know, the local authorities that I've been dealing with, you know, they've been, I think, more or less where there are objections to the placement, they're quite often saying, yes, we agree it's a deprivation of liberty. And the position I'm taking is that, you know, quite often, you know, if they're happy there's a dole there, I'm happy for it to remain in place, because it protects the person, because there is that right to advocacy. It gets those people going in and checking on them, and, you know, making sure, you know, doing your job and doing what you've done for years, and that's a really good safeguard for people. So I think we're still in a wait and see area. I think there's been a few worries. I think there was, one case Kate said to me was about there was a doll in place. There was a condition put on the standard authorisation, which was not being met by the managing authority, and it's quite a difficult case because of the care home had already given notice on the placement, and so he was set to leave there, but they couldn't find somewhere for him to go, and I think the judge dealt with it quite pragmatically in terms of saying, he's got to be able to go out because he wants to go out, and the fact that you haven't arranged it means I'm going to just call, tell them that I'm going to call the director of social services and the deputy and the manager of the care home in to give evidence as to why they're not dealing with this. And I think that was quite a pragmatic approach to dealing with it. But it is important that conditions are adhered to. And if you're in court proceedings, or if you're not in court proceedings, they're not being adhered to, then we can get it into court. And then if you are in court proceedings, we can ask for further evidence. We can get the judge to deal with it in those circumstances. Of course, we've got to look at whether or not that if time has passed and whether or not the condition is still appropriate as to what we have to do with it. But that is something which can happen if you're in court proceedings. There was also, I think, one of the cases was somebody who was at home. There was a really high level of restriction placed on them, and they found that she wasn't deprived of her liberty. And I noticed that was one of the cases by Judge Burrows. So I anticipate that's probably the one that he's writing his judgment on. So we have to wait and see what his full reasoned judgment is. But I think the test in AGNI is quite difficult because the court was clear. The paradigm example is that of a prison cell. And if you're at home in a normal family home surrounded by family, you're already outside of that sort of paradigm test. And then so you sort of stacking it up. It's quite difficult to then prove that it's a deprivation of liberty. And I think the concerning point for all of us, I imagine, on the call was the fact that because they're so disabled, they don't understand what liberty is. And that was mentioned at the hearing in the Supreme Court. That one of the judges raised that, and that was also raised in the judgment. So it is of deep concern that's been raised, and that's how they might handle cases. And I think sort of looking, of course, we're waiting for what comes through and more guidance in the Department of Health and Social Care. But I think as organisations and advocates, I think what is really we've got to try and make sure people know how important advocacy is for people. And we've had another change of Prime Minister. We've got another Secretary of State for Health, but that brings with it an opportunity for it to be reviewed again. So we've got it's a good time to gather lots of evidence as to the usefulness of advocacy for people. And I know, Kate, you're working with this, and I know you're doing this, but I'm just saying it to everybody. But get the examples. We need examples, because I think that's one of the issues we had in the Supreme Court case. We needed concrete examples of why it was affecting people. So get the examples, get it together, and we need to put pressure on the Department of Health and Social Care, but also on Yvette Cooper, the new Minister for Health, and we've got to try and put as much pressure on people to try and look at getting a legislative reform. So you have case law, you have a Supreme Court case, and that's what's law at the moment. But Parliament can go away and they can make a new act, or they can go and adjust the Mental Capacity Act. And say, and that's probably what we would want them to do. We'd want them to look at the legislation and sort of give more description as to what amounts to a deprivation of liberty, and particularly dealing with this issue of a valid consent, because my reading of it, and this is only my personal reading of it, is that it just is completely at odds with what is in the Mental Capacity Act. if you can't understand the relevant information or use it or retain it or communicate a decision, how can you have a sufficient appreciation of the situation to be able to give valid consent? It's just bizarre in my mind. So I think it's get the evidence together and put the pressure on as many people as you can to try and bring legislative change in place. That's through Kate and Black Belt and all the great things that she does, but it's also where appropriate is getting as a sort of media getting the media involved in certain ways as open justice to do that to a certain extent. And I know that the National Autistic Society, MenCap and Mind have also done that. So it's where it's appropriate as an organisation, it's looking at just trying to put pressure on to try and push through legislative change, because my position is that it's been such a backward step for disabled people to say it's they don't deserve to be treated the same that way. I mean, I should be treated. It's just it's abhorrent. We should all have equal rights. We should all be equal under the law. So I'm afraid it's a call to arms and campaign and let's change the law. So.
Thanks, Rebecca. You've touched, I think, upon most people's concerns. The relative normacy phrase is just deeply distressing, isn't it, as a concept? It really is. Gail, did you want to share?
Yes, I meant to say earlier and then got carried away in what I was talking about and didn't. So I work at the National Development Team for Inclusion, and I have an amazing group of colleagues in our research and evaluation team who are just launching a little study, a quick study, looking at case studies where advocacy has been impactful for people as part of deprivation of liberty safeguard processes. So there'll be some information on the website coming out probably today, and we'll share a newsletter this week about how advocacy organisations can get involved in that. We're also crowdsourcing resources to fund that piece of research. So if organisations would like to get involved in helping sponsor some of that work, that would be amazing. But we're really trying to do what Rebecca's talked about and get some evidence together really quickly about how important and why advocacy is important and the impact that advocacy makes within those processes. So yeah, some opportunities to really start to champion advocacy with some real hard evidence behind us.
Thanks, Gail. Before I move on to the question part of this session, so as I mentioned, there were 43 questions submitted in advance. Thank you, you clever group of people, for thinking of all these things. Rebecca, did you have anything final you wanted to say, or are you complete?
I mean, I could talk, but I don't think I've got anything I want to say. So if you want me to answer, I'm happy to do that. So
awesome. Well, I'm going to be coming to you in the questions, I think. So yeah. So what we're going to do now is I'm going to share a slide deck, because it's just easy if you see the questions, I think. And we'll kind of address them, I think, as a panel. We've got a good half hour. We've scheduled this to run till 2 o'clock. Appreciate people might need to leave. But honestly, cannot emphasize this chat box. It is such a golden moment for you to capture and record these examples. There's so much beautiful points coming through. Please keep going with that. Okay, so first set of questions is around evolving case law. So Rebecca, you've kind of touched upon this, but any easy messaging? You don't have to go through each one, by the way. See it as a collective.
I mean, there are court cases being brought at the moment. We haven't got decisions yet. There isn't one source of information, but a really good source of information, look at it, is the 39 Essex mental capacity newsletter. So I suggest they'll email it to you. So if you sign up to it, you'll get these emails through to you. It's a really good place, and they're quite good at getting up-to-date information to you very quickly. And then how was, I think that's a Supreme Court case, conceived in the first place and motivation. So it came from the Attorney General in Northern Ireland, and I think there were budget constraints as to why they brought it. And they were looking at sort of how can they reduce the bureaucracy and, the amount of money it costs for people to do it. So they looked at this issue of valid consent. And the purpose of it was based in sort of a lot of the European law, which has been through the sort of the European Court of Human Rights, and it's looking at consent in different jurisdictions, and the jurisdictions, they don't all have the Mental Capacity Act. So some people, you can have consent, you can have capacity, or full stop for everything, and then you can't have capacity for everything, full stop. And within in those, it's a bit like the Britney Spears case when she had a conservatorship, and so she wasn't allowed to make any of her own decisions, whereas that would not happen in our country because you have the Mental Capacity Act and it's decision specific. So in those areas where it's you decided not to have capacity, there are people within that who could probably have an appreciation of the situation and who would be able to provide consent, sort of applying RMCA. So that's sort of where it's come from, this issue of valid consent. So, I mean, we argued, obviously, that it doesn't apply because we've got the MCA and that's how we should deal with it. But they brought in this European way of looking at it because of the different jurisdictions and the different way it's handled. So hopefully I've dealt with that quite quickly. So, also, subjective consent now be applied to other decisions. The issue of valid consent only applies to this deprivation of liberty, but it does apply across the board. So if it's in hospitals, it applies there as well, and it applies from 16 onwards.
Thanks, Rebecca. Thanks. And just a little note on language, because we know how important and significant it is. So there was a bit of an emphasis before around the person isn't objecting. My understanding of the multifactorial assessment is it's not about an absence of objection, that there has to be valid consent. And I think that for me, I think we need to be using the phrase, what's the evidence of the valid consent? It's not enough that the person isn't objecting. Unless I've misunderstood that wrong, that's my understanding. So it's not like subjective consent, it's valid consent about those things, and that has to be expressed in a positive way. Would you go with that, Rebecca? Is that your understanding, or have I missed?
Yes, that's correct. And I think it's not there had to be a positive thing about the placement, and that's where they gave the valid consent. So it's difficult in the places where they're not because the people where there's no sort of objections, but they're also not particularly liking it, and I think that's where it's really difficult to interpretation. You're saying that they're positive about it because they're just compliant, and there's all question marks around that, and it's going to be extremely difficult to interpret. And I think we could interpret it that they're not positively enjoying it if they're just going through the motions and they're heavily sedated, that sort of thing. So. Absolutely.
And this is where I was involved in talking about 2 weeks ago with Peter Edwards, and we were talking there around advocates. I really think you need to become experts in valid consent, because it's quite complicated and nuanced, and we know about things like learned helplessness. We know about concepts where people say that they're happy but they're not. We know, from first-hand experience, that a person might say to the paid carers they're happy, but will say privately to family, friends, and advocates that they're not. It is complicated. It's really complicated. So I guess that for me is the invitation of let's become experts in that. Let's lean into that, and we become the experts in what valid consent looks like and means, and what the evidence is. Right, going to move on to somebody else going to come in. Rebecca, you're going to...
I'm just going to say, in terms of objections, I mean, it's helpful to know that there was a case in 2016, the RD case, which went through sort of behaviour which could amount to an objection. So it might be worth refreshing. Probably, if anybody's heard us speak, you've probably heard us talk about it. So it's worth sort of looking at that and looking at, is it medication, possible reasons for it, and looking at those it's worth having a look at the case again, looking at that sort of specific section about
Beautiful.
authors' objections.
Yeah,
So
I can see the paper already. It's like, when is an objection, and when is consent valid consent, isn't it? When is it?
Yeah.
Okie dokie. Right. This is really quick. I'm going to cover this one. So, and forgive me, my Welsh friends. I should have said Care Act and Social Service Wellbeing Act. Forgive my omission there. So there are a couple of questions around those adult social care processes, and quite simply, I just wanted to say, none of that's changed. None of that has changed. So please feel robust in ensuring that the local authority and health boards are continuing to do a review, and it's not just an annual review. It's no later than a 12-month review. It is just called a planned review. And that's significant, because if the person's needs are likely to change in 6 months' time, then the review should be scheduled for 6 months' time. And I think that's been lost along the way in these adult social care processes. But yeah, complex cases, and I know complex is a difficult word for lots of us. But yeah, of course, people should be under review. There is a statutory duty for care plans to be under review. So yes, all of that has not changed. Right, Gail, I think the next one might be fairly straightforward, if you can take that one. You just unmute yourself.
So any idea of code of practice? So the kind of questions around guidance. I don't think we've been given a definitive timeline. I think there is a sense of urgency at the Department of Health and Social Care. I think they understand the level of confusion and uncertainty that we've all been expressing. I think they're also starting to have kind of ideas about how they might be able to provide information for different audiences. So families, people who might be themselves in care homes or deprived of their liberty. So no, I don't think we've got a definitive timeline, but I think there is work being done at pace. And care home managers, so there are a number of kind of umbrella organisations that lots of care home organisations are a part of, and I think those are sharing information kind of down to their members. So that's one way, making sure they're also signing up to all of the kind of sources of information that Rebecca's just talked about, and the links that we've shared already. I guess, do we inform the home and the client of these changes? I think you can, but it's really not your responsibility either. And there's something about whose message is it that we're sharing. I think I would be really urging local authorities to be making sure that they are talking to care homes about their responsibilities and their duties. If I was the advocate, I think that's where I'd be focusing my energy on trying to make sure that the local authorities are sharing that information and supporting that upskilling of knowledge with their providers.
Thanks, Gail. And there's a systemic issue there, isn't there, for the advocacy managers? Give us a whoop whoop. Got any advocacy managers in the room? You know, there's a role there, I think, for you to be asking, rather than do we inform, it's kind of you're checking how is the home informing their people and families about these changes, and raising those concerns if you feel that they're not. Yeah. Thanks, Gail. Demi, you've got the easy one. You just unmute.
Well, I am. Had to be done. Yeah, I think this comes back to a lot of what we were talking about before, in that the legislative safeguards are still there. We still have the MCA to rely on. We still have the Care Act. We still have the Human Rights Act. We have all of that to come back to. And, any decisions that are being made should be made in line with the relevant legislative framework. And where we are aware of people and where we can still get those referrals, where we can work with people under a different statutory advocacy strand, where we can push for that, then we still have that advocacy involvement, and that's where we can still be relying on that legislation to challenge decisions where necessary. Obviously, as I touched on before, the MCA should still be applied, and it should always have been and should always still be. But we know that application of that does vary a great deal in actual practice. In terms of the gaps of people that aren't eligible for other forms of statutory advocacy, that's the bit that we don't know about at the moment, and that's the bit where we're trying to get in front of DHSE and make them aware of the gap that is going to be created and how advocacy can be helpful in those settings, the difference that advocacy has made in those situations, and why we do need there to still be some advocacy to bridge that gap and make sure that people do still have safeguards. But yeah, that's the bit that we don't know about at the minute. But obviously the stuff that we do have and we can use to absolutely use to our advantage as much as we can, make use of what we've got. And like you say, Kate, find a way to get in there in terms of the people that we do know about, where we can push for those care out referrals, push for those and get involved. I'm just looking if there's any other questions that aren't. How we influence managing authorities to record objections. I'd imagine as RPRs, we're probably doing that. Especially if we have got people where we're speaking to them and they indicate that they're not happy where they are, but then we look at paperwork and it seems like everything's okay. We're probably having those conversations with care home staff, care home managers about the importance of recording that. And so I guess it's just a case of continuing with that message and potentially from a different focus now, in the sense of it's important to understand what objection is, not just surface level of asking to go home, packing bags, not just those levels of objection, but also objection to restrictions, objections to things like personal care, medication, and why it's important that that's captured and why that's considered as part of a consideration as to whether somebody is deprived.
No, Demi, you've just made me remember there's a word in the AGNI ruling which I like. And this word doesn't appear in the dolls. It doesn't even appear in the LPS, but it appears in AGNI. And do you know what that word is? Happiness. Happiness. AGNI talks about happiness. And I think that's really interesting because it doesn't appear anywhere else. So is there, when we're thinking about safeguarding, because this for me is this is why everybody is so panicked, because the safeguards have been ripped away, haven't they? That they, RPRs, we know they're going to be reduced. People won't have advocacy safeguards. But happiness, oof, does that mark a cultural shift? As advocates, rather than asking, is the person deprived of the liberty, AGNI kind of invites us to go, is the person happy? I know which question I like. The robotic, is the person deprived of their liberty? It sucks us into this, I think, quite inhuman, weird framework. Is the person happy? That calls to humanity, all the good soul stuff that I think as advocates we want to be swimming in. So I just wanted to chuck that in there because I forgot to mention about happiness, and I think it's really significant that it talks about happiness. I don't know whether, Rebecca, when you were in the court, did that come through or?
No, I didn't pick up on that, but I think it is a really good thing to highlight. And I have had colleagues now say, well, when I go to visit them, I'm just applying happiness tests. Are they happy there or not? Are they not happy there? So, and I think sometimes we do forget it, don't we? Sometimes we forget. We look at what is it in their best interests. We don't think. Is it? Are they happy there? Do they want it to happen? We wishes and feelings. Well, they don't want to do this, but it is in their best interests, and it's that constant balancing. So, I think it's really valid to we as people we want people to be happy, don't we? So I think it is really valid, and we can't always achieve it. We can't always achieve it, but it should be their first point of call. What will make them happy? So I think you're right to highlight it. So.
Yeah. And it's not the answer at all, but it's an interesting shift, isn't it? We want to, advocacy surely is about influence. Is this a moment where we can influence? Right, stay there, Rebecca. You're up next.
Oh,
So the next one is around challenging. Do you if you had any thoughts on this one, or whether it's just a case of business as usual?
Well, I think it's the question of challenging. I mean, you can still bring corporate protection proceedings. You've still got Section 16 proceedings. You've still got complaints. You've still got that complaint system there as well, which it can sometimes work and make a difference. So there's still those routes of challenge. There's also judicial review. So if you're in there and you see somebody, you can still speak to lawyers. We can still challenge things. Just because there's not the standard authorization in place doesn't mean they haven't got a right to challenge. There are still those rights of challenge there. So and I think the easy one is the Section 1/6 of the MCA. Is it the least restrictive option? Is it best interest? Is it the least restrictive option? Those are the things you need to be thinking about, and do they have capacity? If there's clear restrictions in place, even if they're not to do with the care of residents, it's about who they're going to see, then there's a challenge there, isn't there? So we can do that. Can advocates challenge it? Be it yes, of course advocates can challenge that. And I think it's you've got to consider at some point, is it if the local authority aren't doing what appears to be in their best interest, does it amount to safeguarding? Should you be raising a safeguarding alert at that point? I can't tell you, it's matter by matter thing, but it's worth having in your mind. Is this getting to the seriousness that is now putting them at risk? Do I need to raise safeguarding about it? So it's worth having that in your mind. I don't think you can make a care home reapply, but you can raise it with the local authority. You think there's a dole, and there should be an standard authorization. So then hopefully the local authority will then take the right steps, depending on what local authority is. But you can't make them reapply, but you can raise it with the local authority. And again, does it fall within the realms of safeguarding? Is it that crucial to think about? So,
and that for me would be a place to contact your legal friends and look for solicitors to sound things out if to see if there's a legal route. Thanks, Rebecca. Right, Gail. I think you said you might have a little gander at these. So not strictly multifactorial, but the word multifactorial assessment just makes me giggle. I don't know who came up with it.
I can't really even say it. Can you say it multifactorial? Anyway.
Say it really Scouse if you want.
So I think kind of as we've just talked about, there's going to be care homes and care home managers very much deciding, but where there is any level of doubt, we're saying, aren't we, that those referrals should still be being made. As Rebecca's just talked about, kind of carry on those conversations with the DOLS teams. We don't really know, I don't think yet, the weight to apply to different factors, but actually maybe there's an opportunity for us there, isn't there, in making sure that the considerations are being really focused on the person and what we know about that person and their views, wishes and preferences, how they're experiencing life, how they're experiencing restrictions. And I think there's an opportunity for us to really emphasize the role that advocates can play in establishing whether or not there is a deprivation of liberty, and understanding what the person's preferences are, as far as we're able to establishing them. So I think there's a really interesting opportunity for us to think about, where does advocacy happen in this process? Where can we pushing for advocacy to be happening within this process? And actually, at that point of thinking, is this person or not deprived of their liberty, when there are all those factors to be being considered, actually isn't that the perfect place for people to have a representative voice and independent representations? I think there's a real chance for us there to kind of get in and make sure we're championing rights and voices at that point.
I'd just like to add to Gail, I sort of agree everything you said, and it's because there's not a concrete list, you can bring in everything that's relevant to that person, and that's a really important thing for advocates to do. So it's helpful we haven't got a concrete list, you just bring in what's for them. So it makes it harder to make people do it, but when you're involved, you make it really tailored. So
yeah, there's an opportunity, isn't there?
Can I get a quick yay or nay in the chat box for everyone? So the question is, and this is just for advocates, if that's okay, because I think we've got friends as well here, but just for advocates, if you're an advocate, have you been present or supported somebody through a multifactorial assessment in the last 8 weeks? So yay or nay? Well, that's interesting. Okay, I'm going to be really bold and egg Gail's point. You have to be there. You have to make a case. Find a way of getting in that process. Now, you're going to say to me, well, we need a referral. No, you don't. IMCare needs to be instructed. And this is going to be really controversial. But I'm going to lean in and be controversial. Care Act advocacy, you don't need a referral, right? I know that's going to piss people off, but I don't think you need a referral. The local authority has to agree if somebody's eligible. So the local authority agrees, or in Wales, you agrees if somebody is eligible, but you don't physically need a piece of paper that says this is a referral. Okay, referral processes are there to help you manage your delivery. The point of your service is not referral. So if you're aware of somebody through your Care Act role or through your RPR role, which may or may not be coming to an end, you have information about, you should be classed as a relevant party, really, in terms of that best interest checklist, where it says anyone with an interest in the person's welfare, that's you. And you're there for that beautiful principle too, of all practicable steps to help the person be involved. That you're there as an advocate. You don't have to be an IMCare to perform that function. And everyone not everyone, most people going through DOLS processes. CHC, people who are funded with CHC and self-funders won't trigger Care Act or independent professional advocacy, but most people will. So most people will have access to an advocate. So this is your invitation. This is your reason to knock on that door and really insist on being present at the multifactorial assessment. Because if you're not there, who's defending the person's rights? And I'm going to take a breath now. Anybody want to pick up on that?
Can I just come in on that, Kate? I think a lot will depend on actually how those assessments are actually being carried out, and I think that's not really a question that I've asked yet, in terms of how BIAs are going about it and whether it's actually going to be any different, or if they're doing their assessments as they normally would, and then sort of when they get back are reviewing everything together and sort of considering all the multi-factors at that point. Yeah, I guess it sort of depends how they're really going to go about it in terms of how we would be involved in that. But I suppose if there is an advocate involved with someone who is being assessed for a DOLS authorization, certainly where we work, the BIA would speak to that advocate in some form. So whether that be we've had a referral for a 39A IMCA, or there's an RPR who has been involved, or there is a Care Act advocate involved, if there's an advocate known to that person, the BIA will consult with them at some point. So we may not be necessarily present at that assessment because they may not be sat doing the assessment in a way that looks like that, if that makes sense. It might not look any different to how they've done things previously. But then when they get back, the way that they consider actually whether this person is deprived is different. So I think there is still a lot of ways that advocates can be involved and make sure that the views of the person are captured in having that conversation with the BIA. And I think there's been some things that have popped up in the chat box from BIAs who have said that if there was an advocate and they haven't been involved, then that wouldn't pass their scrutiny process, which is really good to see as well, and reassuring in that sense.
Yeah. And aren't we seeing that without that guidance, how this is going to be quite inconsistent? With some, I'm reading Richard said there are some people with telephone assessments, remote decision making without even meeting the person. None of this is new to you guys. None of it. Crap decision making is kind of why advocacy exists. Let's be honest, isn't it? if public bodies got it right, we wouldn't need to be doing advocacy. Just to
None of us would need to be here, would we?
Exactly, Rebecca. Go on, you're going to come in there as well.
Well, none of us would need to be here to have good decision making. But I think going back to that point about the advocates being involved, I mean, the reality is if you've got a long-standing relationship with this person, I've worked with some RPRs and they've been going to see people for like years and years and years. And, if you've got that long-standing relationship with somebody, you're probably going to be the best person to talk about their wishes and feelings and to try and understand whether or not they can give a valid consent. You're going to be one of the best sources for that. So if you're being excluded from that, and you've got a real right to complaints there, and then there's a question mark. Has that been made? Has that decision eventually been made appropriately? And if you don't think it is, then we can take it to court. So it's there are routes. There are there's not all hope is lost with the AGNI case. There are still routes of challenge. There is work to do for us to try and get it as good as we possibly can, but not the law is still there. We can still challenge. So
absolutely, yeah. And I'll just draw your attention, Rebecca, to Kay's comment in the chat. Kay said, I've seen letters in clients' care plans telling care homes they are not renewing doles without carrying out an assessment. That is the type of thing I'd be jumping on, and I'd be getting a copy of that letter, and I'd be raising that with the MCA lead, and I'd be probably getting a lawyer friend to tell me whether that's legally defensible, because the whole point of multifactorial assessment is it's an assessment, but unless something has drastically changed, and without knowing the facts, but that is the type of thing I'd be really, really sensitive to, as an advocate.
And I think just on that point, if there's any sort of blanket policies across any sort of care homes or local authorities, then that is poor decision making and is ripe for challenge. So it's all got to be, specific to that person, the multifactorial test, So blanket policies, blanket care homes going, no, we're not doing it. It's, it's a serious concern and it's poor decision making and it needs to be challenged. So
definitely. Right, we're nearly there, guys. We're perfect timing. Questions about evolving case law. I'm sure they've allocated this to anyone. Or Demi. No, sorry, it's about Demi. Yeah, sorry.
All stuff, yeah. I think the starting point for a lot of these questions is that whilst the law that tells us what a deprivation of liberty has changed, our role as RPR hasn't. So looking particularly at that first question, carry on doing what you're doing. I would always be very much led by the person in terms of what they want to do as far as they're able to tell me. If they want to go, if they want me to contact a solicitor straight away rather than going directly to the local authority, then that's what I will do. And I'm sort of led by the person in that. If you've been waiting for a long time, contacting a solicitor, and sometimes that letter before action can magically make a social worker appear. But yeah, I don't think that's necessarily anything different. Our role is the same in that sense. Similarly, for the question about are we still required to make a decision around a Section 21A, again, our role and the things that we need to consider as set out in the RD case law, that's not changed. And what we're doing as RPR hasn't changed in that sense. If a Section 12 doctor and a BIA have differing views, I would imagine that's for the BIA to discuss with probably their legal team in terms of how they're going to resolve any disputes that they have in that sense. Obligations of social worker or CHC assessor where I'm assuming that means a 1.2 expires. Again, I think they will be having conversations with their legal team about whether the situation appears to be a deprivation of liberty, potentially going to court where there is that aspect of doubt to ask a judge to make a determination on that. And why aren't supervisory bodies involving advocates in any reviews? I'm assuming they mean Part 8 reviews with the mention of doles, and I think that's a conversation for the supervisory body to ask why advocates aren't being involved, and talking about, as we've just talked about, how we are somebody who knows the person very well placed to be involved and support the person through that review, share information. And yeah, sort of putting that back on the supervisory body in terms of that they should be involving advocates and ask if that's not happening, asking why not. If it's a case of Care Act reviews, it would be a case of pushing back on the local authority and reminding them of their duty to refer for advocacy where a review is taking place.
I think it's probably sorry to jump in again. I'm talking quite a lot, so I am sorry. I think it's worth remembering, if there is a dispute and it can't be resolved in the best interest meeting process, then the next place is the court of protection. So if they can't agree if they've got capacity or not, then it needs to be resolved by the court. So that process is still there. So if there's disputes between the professionals, then go, are you going to take this to court because we can't decide what's going on? So the route's there, and don't forget. So.
Thank you. Right, then the last bunch of questions was about questions specific to advocacy. So both Demi and Gail have made reference to a model which is called residential visiting advocacy. So this is nothing new. Children's services have been running that since the 1980s. And it's where you visit a care home, an institutional setting. IMHAs will be doing this. They'll be visiting wards. They'll be dropping in on wards. There is no reason why adult social care advocacy cannot offer that drop-in. That can be, when you visit a care home, let's say, you just have a cup of tea in the lounge. I looked at the impact assessment for Care Act. And the impact assessment is a document that the government produces every time a new piece of legislation is introduced, and it looks at different options from this is the problem we're trying to fix. These are different ways we could fix it. This is what happens if we do nothing, and it costs it. I mention it because Care Act advocacy, ready for this? So it's just Care Act advocacy, not social service wellbeing advocacy. Do you know how many hours are allocated to Care Act advocacy? Put your answer in the chat box. So this is the functions of the assessment, the support plan, and the review. It's not safeguarding. So it's just about, thanks Amanda, Tanya for stepping in and doing your suggestions. Beautiful. No one's correct, by the way. 3, poof, that's low. So the whole process from assessment, planning, and review. 4, no one's got it yet. There isn't a limit. You're correct, but there's guidance. So they said the average. So basically, how we're going to plan the funding. It's Sophie's got it. It's 22. It's 22 hours. Now I think that's interesting. I think we are cutting ourselves short. I don't actually think we spend 22 hours with people. Quick, do that. That's 2 hours a month. I mean, can you see how you could actually carry on in your paid RPR role under the, as a Care Act advocate? Do the decision making, and then for people, and it's not for everybody who has a Care Act advocate. If you've got capacity and you can pick up the phone and say things aren't going right, I want a review. You don't need to keep in touch, I think, with those people. But if you've got somebody who lacks capacity, communication is very personalised, they don't have family and friends, nobody visits them, then as an advocate, that would be my priority. I'd be wanting to check in with them every 2 to 3 months as a Care Act advocate under the banner of review. I don't know, Gail, Demra, do you have any thoughts on that? But we need to challenge ourselves on this rhetoric that there is no money, there is no time. I'm challenging that idea. I think there is. I think there is. Just pause if Gail, Demi wanted to disagree or agree.
No, agree, and we've generated this myth that we have to have a referral to work with somebody under the Care Act, and that's not what the Care Act says.
No,
it might be what local contracts say, but then there's a place to negotiate, isn't there, then around how advocacy's commissioned and delivered and contracted to make sure it's in line with what the Care Act said. And so we've kind of let ourselves get squashed into little corners of kind of tiny
Service
slices
land.
of delivery of service land. Yeah.
Of service land. If somebody's already known to you because you work with them as an MCare, this is a genuine question. Why do you need a piece of paper that says that they're being referred for Care Act? That piece of paper is not going to give you anything about contact details, risk that you don't already know.
And also, you know, you've been supporting somebody during their assessment and reading case files. I see it all the time. I'm going to have to close the case unless I get another referral for the care and support planning, and then I'm going to have another referral, please. I mean, it's just bureaucracy for the sake of it, isn't it? It's absolutely silly when resources are as stretched as they are, that we're insisting on people filling in extra forms when we know that they're eligible and we know this process is happening. It's just nonsensical.
So if this has piqued your curiosity, I can see the chat box go, ah! I can feel people like, oh no, we need a referral. Check it, do your own diligence. Go check it. Show me in the Care Act where it says you need a referral. IMCare, definitely. IMCare, clear. It says you need to be instructed. It says you need to be instructed. So you need something to say the local authority or NHS are instructing you as an MCare. Care Act and MCare doesn't say that. So unless you can find something, I invite you to be creative. And as Gail said, there's a conversation there to have with commissioners to make your job easy. Because I think you guys are busy. I really think you guys are busy. And I think you've got better things to do with your time than I think the technical phrase is fannying about with bits of paper. You want to spend your time with the person doing the advocacy. Yeah. Amanda, so much time persuading people. I mean, some of your referral forms as well, guys, are like 7 pages long. I wouldn't fill it in. So some referral forms are so bureaucratic, you know, asking for people's equality data. I mean, I feel quite uncomfortable actually asking for somebody else to say what my equality data is. And yet we put that in, lots of organisations put that on a referral form. So if there's something to take, just have a little look at that. Have a little look at, do we actually need all this service land driven approaches when the point of advocacy is people, isn't it? It's people's happiness and people's joy, and how do we promote their voice and autonomy. Right, 2 minutes to go.
Can I just quickly add in my 2 pence as an advocacy provider? And looking at the chat, there's a lot of people that are saying the issue isn't necessarily with the legislation, it's with contracts. And I think a lot of people will be in a similar situation there in terms of it's commissioning that is dictating a lot of their approach. And I think we do have an opportunity at this point to rethink how we approach things and to have those conversations. But I think at the moment, people may feel, constrained by their contractual arrangements and what they're able to offer. But as we've said before, we've probably got an additional resource in terms of there was a big boom in RPR referrals, so there's more resource then. We can be creative and think about how we could adjust some of our offer and have those conversations with commissioners. But I think it's a conversation to have, but I think it will, a lot of providers will find it difficult to just immediately sort of switch to that approach without having that conversation with commissioners. But there's definitely a conversation that can be had about thinking about how we can be, like you say, more creative in our approach and how we can try and address the gap in safeguard using the legislation that we've got and making that argument to commissioners and trying to sort of get around some of the red tape that may be in the contracts.
Thanks, Demi. Right, last one. Free for all, guys. Anybody want to take any of these? I mean, 16, 17-year-olds, Rebecca, there's nothing specific, is there, for that group?
No, I mean, they fell outside the standard authorisation scope, so that only applies when you're 18, but AGNI does apply to them still. So they fall in that definition of whatever it is to be deprived of your liberty. So there's still that it's got to be applied. There's nothing specific to them. We're waiting on further guidance on them, but they're always outside of the dolls approach anyway. So, and it might be still the case that if it gets to court, the court will want to look at it because there's always those transition arrangements which have to take place between child and adult services and changes of placements. So it's, you know, it's worth considering. You get a 16 or 17-year-old, what's happening when they turn 18? Are they losing the education placement? Are they, you know, you've got to have those considerations, and I'm sure you're already thinking about those and their happiness as well. So
that's the good that'll come with the change, I think. Being my rainbow optimist, I feel like I'm a My Little Pony sometimes, or what with the Care Bears with the rainbows on the stomach. I think the good that'll come will be the happiness bit, you know, and more old-fashioned advocacy rather than the siloed IMCA. That could be something. Could be residential visiting advocacy. Yeah, I've got to be careful not denying and just pretending all the crap isn't happening, that people will lose. People will lose out on their rights. But it's, yeah, like everything in life, nothing is all bad or all good. It's, yeah, just is, isn't it? Yeah. The BIA's losing their jobs, do you think, Gail? Possibly. There'll be fewer dolls, won't there? Fewer dolls assessments. Yeah. But we don't know. Yeah, don't know. All right then, that is the end of the session. Look at that. Oh my God, I've never finished on time. That's remarkable. It must be my beautiful colleagues. We'll do another one maybe in September. And the other thing to do a shout out for is conference. So conference, oh my gosh, it's going to be so packed. I was saying to Gail and Demi today, there's a new mental capacity bill going through that's talking about assessing capacity and making that more robust. I be honest, I didn't know it was happening. So much happening at the moment. So if you're able to, please do join us in Birmingham in November. We do have funded tickets for people who draw on services and families and carers or self-advocates. And we do, because of sponsorship from Emma Mitchell, we can keep the ticket price low. But come, because oh my gosh, we need to be unified, don't we, not thinking, and joined up. I'll turn to my friends and colleagues. Any final words from anyone? Let's go round. Demi?
Just to echo what Gail and I said earlier, if you are interested in getting involved in the conversation in the subgroup, I think Gail's popped the email address in the chat box. Send a message and get involved if you would like to. We're keeping the conversation going, and sort of having these conversations about what's important to put in front of DHSE and for them to be aware of. So yeah, the more the merrier.
Gail, any final words?
Just keep on being awesome. Advocating really strongly for people, remembering people's rights, helping people have a voice.
Yeah, I'm Rebecca.
I don't think I have anything to add. Just keep on doing a great job and don't shy away from a challenge and an argument when it's needed. We are people you're supporting. So
Well,
and we're here if you need us.
Let's see your advocacy guns. Come on, Gail, let's do the guns. Let's do a double gunnage. Yeah. Thanks, Demi. On that beautiful, terrifying image, I'll bid you a lovely afternoon and see you on the other side of the summer. All right then, friends. Take care. Bye, everyone. Right, let me stop the recording.